Okay.
Shall we start, sir?
Yes.
Shall we start?
Yes.
Thank you, sir, for accepting our invitation and taking out time from your busy schedule. So today we have on board with us Nitin Gupta, sir. He is managing partner at the Law Chambers. He's an impaneled arbitrator with the Delhi International Arbitration Center and Construction Industry Arbitration Council, and also impaneled independent director with Indian Institute of Corporate Affairs. So today, sir will be having a discussion with us on the topic: Can non-signatories to an arbitration agreement be made party to an arbitration? What is the group of doctrine with respect to arbitration? So, sir, shall we go ahead?
Yes.
So, sir,
Yes.
for all of us, can you tell us, like, as per the Arbitration and Conciliation Act 1996, who can be referred to arbitration?
So this session is going to be slightly technical because the topic that has been chosen is not really in the statute book. It's
Yes.
coming out of precedents which is coming from the courts. If you have a look at Section 2H of the Arbitration Conciliation Act, it defines party, which means
Yes.
a party to an arbitration agreement, which would mean a signatory to the arbitration agreement. If you read Section 7 of the Arbitration Conciliation Act, it says arbitration agreement means an agreement by the parties to submit the arbitration or all to submit to arbitration all or certain disputes which have arisen. So the definition of party, strictly speaking, in terms of the act, only includes people who are signatories to, or persons who are signatories to the arbitration agreement. This scope has been expanded by the courts, more so Supreme Court. In the matter of Cox and Kings, which is a judgment of 2023, if I'm not wrong, Cox and Kings very clearly says that the definition of party under Section 21H, read with Section 7 of the Arbitration Act, shall include both signatories as well as non-signatories. So this is something which has been, the definition has been expanded by the Supreme Court. Also, the Supreme Court says the requirement of a written agreement, written arbitration agreement under Section 7 of the Act does not exclude the possibility of binding non-signatory parties. So, by virtue of not only the judgment of Cox and Kings, but certain other judgments also, which I'll take you through, the Supreme Court has expanded the scope of parties not only who are signatory to the agreement, but also who are non-signatory.
Okay.
I hope I haven't confused you and answered the question appropriately.
Yes, sir. Yes, sir. So, can what is the group of doctrine, group of companies doctrine with respect to arbitration?
Okay, this is yet again going to be very technical, but I can, of course, share the list of judgments which we have looked into and found out that how and when and how did the group of companies doctrine came into place. So this goes back to as early as 2010. There was a judgment of Indo-Wind Energy Limited, which was a Section 11 case, which is appointment of an arbitrator, where the Supreme Court held strict interpretation of 7 and said nothing doing, non-signatories will not be made a party. Then came a judgment of Chloro Controls India Private Limited. This is a 2013 judgment of the Supreme Court, which dealt with Section 45 of the Act, which means a foreign award. This was dealing with the enforcement of a foreign award which was passed, in which the court for the first time came up with this doctrine, which is called the Group of Companies Doctrine, and laid down a few principles. It said that it can be binding on a non-signatory. What needs to be seen is the mutual intention. What was the intention behind entering into those agreements? Did it bind both signatory as well as non-signatory? Was there a direct relationship and commonality of the subject matter? And since when two companies enter into an agreement, there are multiple agreements and there is one composite transaction. So Supreme Court said a composite transaction has to be seen, and even if there are multiple agreements. So what did the doctrine really say? It said not only the company with which you have entered into an agreement will be made a party, which is a signatory, but it could also include the affiliates, sister concern, parent concern, holding company, etc. This is the first time the doctrine came into effect insofar as Supreme Court is concerned. But this was in the nature of an international award. Cox and Kings, which I'm going to come to towards the end, is for domestic. Now, post Chloro, another judgment came before the court. Another case came before the court, which is a 2018 case called Amit Lalchand Shah. This was a case under Section 8 of the Arbitration Conciliation Act. I hope you're aware what Section 8 is. Section 8 is in case there is a suit which has been filed before the court, and if there's an arbitration agreement, it is a duty of the court to refer the matter to arbitration. So under this provision, this particular case came before the court. Let's forget the facts for 1 minute. What the Supreme Court really relied upon, because this is the first time it came in an Indian context. So it did rely on Chloro, and it said if the mother agreement contains an arbitration clause and is a party to an interconnected agreement, and there is a common intention, common goal, mutual intention, then a non-signatory can be made a party. So this is the first time it came in the Indian context. I'll take you again to another case which was in the Indian context. This was in 2017. This was called Duro Felgura SA. Here, this was a Section 11, which is appointment of an arbitrator. This came before the Supreme Court. In this, the Supreme Court did not invoke this particular doctrine, saying that there were 5 separate agreements, and since the intention of the parties in all those 5 agreements were not interconnected, so we are not going to apply this principle. This again came up, the doctrine again came up before the Supreme Court in 2018 in a Section 36, which is enforcement of a domestic award, where again Supreme Court relied upon Chloro and said the intention to bind the signatory and non-signatory has to be seen. The commonality of subject matter has to be seen. The transaction as a composite, in a composite nature, has to be seen. The relationship of signatory and non-signatory has to be seen. And what is the mutual intention? It appears I'm confusing you more, or am I making it too theoretical?
No, it's going fine. It's going really fine.
Thereafter, in 2019, yet another case came before Supreme Court. This was again a Section 11, which was again domestic. Here, the Supreme Court did not invoke this doctrine because the facts were different, and the Supreme Court felt that there was no commonality, so there is no occasion for us to invoke this doctrine. 2020, this is again a Section 11 case where the Supreme Court did invoke the doctrine of group of companies, as there was a common and clear intention, and the conduct of the parties showed that they wanted to be bound by that particular agreement, which means both signatory and non-signatory both showed that they were inclined to they had a common intention behind it, and both signatory and non-signatory both were getting affected. Now we come to the last one, which is the most recent one, is Cox and Kings. So Cox and Kings, again, the Supreme Court decided the group of companies doctrine, not any different from what it had already concluded earlier in Chloro and followed by the judgments which I already told you. But the Supreme Court here relied upon the various international uh, the intention of the international courts and what the other jurisdictions in the world were doing. So the Supreme Court, while deciding this doctrine, relied upon France and Switzerland, which followed the doctrine. Though this doctrine of group of companies was uh, uh, evolved by England, but the Supreme Court observed that now that England and USA both were taking a very conservative view to that. They also relied on Singapore, which said they do not follow this doctrine. So while deciding the same common factors which it had already mentioned, it had already dealt with earlier, the Supreme Court decided on the doctrine and said the same thing. The conduct has to be seen, a common intention has to be seen, certain factors had to be seen. Those factors were covered in yet another judgment, which I'll just tell you. And in case of a complex transaction where multiple parties are concerned and multiple agreements are there, then this doctrine must be used. But they said, even if we are exercising this doctrine, it is the job of the arbitral tribunal which will be formed to decide whether a non-signatory would be bound by that agreement or not. At best, the court will give only a prima facie. Surprisingly, the Supreme Court relied on this doctrine to the extent that in its conclusion said that the group of companies doctrine should be retained in the Indian arbitration jurisprudence, considering its utility in determining the intention of the parties in the context of complex transaction involving multiple parties and multiple agreements. So the group of companies doctrine, the factors which Supreme Court said should be looked into by the courts was noted in a judgment called Discovery Enterprises. This is a judgment of 2022, if I'm not wrong. Yes, it's a judgment of 2022. So the Supreme Court in this case held that the factors which have to be looked into are the mutual intention of the parties, which I already told you, which is not any different from chloro. The relationship of a non-signatory to a party which is a signatory to the agreement, the commonality of the subject matter, the composite nature of the transaction, and the performance of the contract. To put it simply, in the event there is a contract which has to be performed by one particular party who is a signatory to an agreement, but there are other parties also involved, for example a contractor and a subcontractor and again a subcontractor, but if the common goal is the performance of that particular contract and everybody is affected by either the employer not supplying a particular thing or a particular contractor not doing a particular thing, and there is not only one transaction, there are multiple transactions, there are multiple contracts. So there, this group of companies doctrine can be invoked, or in complex situations where there's a shareholders agreement. There's a shareholders agreement where one is an Indian party, one is a party which is based in England, one is a party which is based in Switzerland. They could be shareholders in a company where there could be multiple shareholders. So there is a shareholders agreement, and there is a joint venture agreement. There is a agreement for providing royalty to somebody. There is an agreement where somebody is giving a technical know-how. For example, a foreign company is trying to give all these information to or helping out an Indian company and doing business with an Indian company, and all these agreements are executed. Shareholders agreement is executed because they also want a piece of the cake. In case the business is doing well, they also want some part of the business or make some money out of it. So there are multiple agreements which are executed, and once the dispute starts, the dispute has not only started with one particular agreement, but with multiple agreements. So people can be signatory to certain agreements, people cannot be signatory to certain agreements. In that case, where the entire transaction is so complex, then this particular doctrine can be invoked, which is called the group of companies doctrine. Now, strictly speaking, the group of company doctrines would mean only a holding subsidiary, affiliate, sister concern, common shareholders, common directors, etc. This would not mean where it is not a group of company, which means there are two independent identities. One is a signatory, one is not a signatory, and may not be related as two different companies. There could be two different entities. It could be one. It could be a partnership firm also. It could be an individual also, which is not covered under this doctrine. But what the Supreme Court interestingly do say in Cox and Kings also, that the Supreme Court does acknowledge that a signatory to an arbitration agreement would any event be referred to arbitration, but a non-signatory can also be referred. So, insofar as Cox and Kings are concerned, it's primarily based on this doctrine, but the Supreme Court does touch upon this part of a non-signatory, but not a part of a group of company, etc., etc. How confused are you?
No, it's going well, clear.
Okay.
So, how do the institutional bodies like DIC, Delhi International Arbitration, or or the other bodies deal with the group of companies doctrine, or are non-signatories to an arbitration agreement?
See, I have not come across any such case where institutional arbitration, uh, where some party wanted to invoke uh, arbitration against a non-signatory. But what I
Okay.
think, because that is what the trend of the court is also, that probably what would happen is that, say for example, you want to invoke arbitration against me because we have a contract, and you invoke that arbitration against me, and you also give the notice of invocation to Mr. X also, because you feel that Mr. X should also be a party to this, though he is not a signatory. So you would probably write to a DIAC or any other institute in India and request that arbitration should be invoked against both of them. What I think the arbitral institute would do is, listen, we are only going to issue notice to the person who's signatory. If you think Mr. X also needs to be included in the arbitration agreement, then you make an application before the arbitrator. That is what I think the institute would do. The institute on its own may not issue a notice, or may not include a non-signatory to the arbitration. That's my view.
Okay. So can the non-signatories to an arbitration agreement be made a party even without issuing a notice?
Okay, this is a very interesting question. I just came across a particular judgment of the Delhi High Court, where, and it's a very recent judgment of 8th of July 2024. In this case, one of the parties to the arbitration agreement had invoked arbitration against the opposite party, which was also a signatory to the agreement. Now they invoke this particular they invoke a Section 21 notice invoking arbitration against the signatory, and the party doesn't respond. They go to the court, court goes to the court and says, please appoint an arbitrator. The court appoints an arbitrator. When the matter is before the arbitral tribunal, one of the party decides to file an application saying, apart from the person who's already made a party, I want to include two more people. So the arbitrator decides, nothing doing, I am not going to make these two parties. Against that particular order, the other side comes to the court, which is the judgment I'm telling you, which is a recent judgment of 8th of July, where the court said, okay, we have merits and everything. Firstly, you neither invoked an arbitration under Section 21 of the Act against those two non-signatories. Secondly, even in the Section 11, you did not make them a party. Now, when the arbitration proceedings are continuing, you have added two more parties there, which the arbitrator has said no. So the court said, since you did not invoke arbitration under 21 of the Act, which is the first step to be done in an arbitration agreement, when you want to invoke an arbitration, and also you did not make them a party before the court in Section 11, so now you do not have the right. Okay. I do not know the fate of this. It could be challenged before the Supreme Court. Maybe the law changes, but as of now, this appears to be the most recent judgment. And otherwise, the judicial trend these days is very simple. I can tell you a judgment which is as recent as 22nd of July 24, passed by Delhi High Court, where Section 21 notice invoking arbitration was invoked against a signatory as well as two or three non-signatories. This is a Section 11 which was filed before the High Court, in which in which both the signatories as well as non-signatories were made respondents. And the court asked them, okay, what is your response to that? Insofar as signatory is concerned, there was no problem. Two signatories will definitely be referred to arbitration. But the two non-signatories, the court decided that we will only give a prima facie. So the court's prima facie view in that particular case was one party they thought should be made a party, the other party they had a prima facie view that it should not be made a party. However, the court said, though we are giving this prima facie view, but it is completely up to you. I'm making an arbitral tribunal for you. You can implead them as a party there. Whether the tribunal agrees to make them a party or does not agree to make them a party is between the arbitral tribunal and you. Okay. Because my role in Section 11 is very, very limited by one party to the agreement, to one of the signatories as well as two non-signatories. Can you hear me?
Yes, sir. Sir, I can see you very well. I can hear also.
Yeah. So, what do you call, the Section 21 notice was issued to one of the parties to the agreement and two non-signatories to the parties. Since they did not appoint an arbitrator, the party which had invoked the 21 notice approached the court in a Section 11 seeking appointment of an arbitrator. So the court said, okay, insofar as the signatory to the arbitration agreement is concerned, there is no difficulty. They will most certainly become a party to the arbitration agreement. But insofar as non-signatories are concerned, the court said we will only form a prima facie view which is not binding on the arbitral tribunal. So the court, after understanding the merits of the matter, felt that one of the non-signatories should be made a party to the arbitration proceedings and one of the non-signatories should not be made a party. But the court said this is only a prima facie view which the court is exercising. The court is not imposing upon the parties whether they can be made a party or not made a party. It is for the arbitral tribunal to decide.
Okay.
So I was in fact wondering if all these judgments taken into consideration, what is the view of the Law Commission of India? Because strictly speaking, if we talk about whether we talk about the group of companies doctrine or whether we talk about non-signatories being made party to the arbitration agreement, strictly speaking, that was never the intention of the act.
Yes, sir.
The intention of the act always said, if you have signed the agreement, you will be excluded. If you have not signed it, you have got nothing to do with it. But the court seems to have expanded as an act, and as I told you, Cox and the commission whether they should consider this aspect, because I have not studied. Well, as of now, that is where the law stands. Whether the law would change and would become completely what was decided in 2010 by the Supreme Court, that if you're a senator, it would be included, otherwise you would not be included. But, that it the agreement must be writing documents by including communication through electronic, meet an email, and if you ask me, I would think it would also include Telegram and WhatsApp. And I'm sure there are other apps also of similar nature, which would provide a record of the agreement or an exchange. This is very surprising, or an exchange of statement of claims and defense in which the existence of the agreement is alleged by one and not denied by the other. So this is like arbitration has started, statement of claim has been filed, and the respondent says, okay, fine, it has been done, I am not disputing it, let the arbitration continue. But the Act nowhere contemplates non-signatory to be a party. The Act nowhere contemplates this particular doctrine. It's like you coming up with a group of companies doctrine, tomorrow you will come up with a non-signatory to an agreement doctrine. So since this is completely missing from the statute book, it should either be looked into more details, and probably the parliament should amend the act to take into consideration these particular judgments, because all these judgments which are referred to started from 2013, and the act has been amended in 2015. It was not taken into consideration. Yet another amendment came in 2019. Even then, it was not taken into consideration. Now, chloro is as early as 2023, and let's see if the law commission suggests it to the law ministry and it is taken up, because this is like opening up a Pandora's box. I am not a signatory. I had a discussion with few of the companies. They said they're now very scared. The holding companies which are sitting in US or in Europe, and they have their Indian subsidiaries. So you may choose to have an agreement with an Indian entity while you are in India, and the Indian wholly owned subsidiary is taking some assistance from the parent company outside India. They will also be including. This is exactly what happened in Cox.
Mm-hmm.
So this is a very scary situation for companies, where they don't know that their parent company anywhere in the world or any of their affiliates or a group of company affiliates, sister concern, common shareholders, wholly owned, different wholly owned subsidiary in a different country be involved also. Of course, they are unhappy about the DMRC judgment also, but that's a topic for another day. But
Yes,
this is like opening up a Pandora's box that, even if so basically, nobody should help the other till such time they're signatory, because they don't know if they'll be implicated in the proceedings or not. And it is left open to the courts to take into consideration. So I feel if a court is taking a prima facie view, for an arbitral tribunal to take a contrary would be slightly difficult. I haven't come across that situation or read any judgment which says that it would be that the court held something else and the arbitral tribunal has held something else, because a prima facie view in itself is good enough a view for an arbitral tribunal not to override even the prima facie view of a court. Because this was never the intention of the act. Is the doctrine good or bad? Only the companies who are in it and have got troubled by it can answer it best.
Yes, very well.
Or the non-signatories who had got nothing to do with the agreement, if that's what they thought, and they have been made party to the agreement or to the proceeding, can answer it the best. If you would want details of all these judgments, I can send an email with all the links of these judgments if you are desirous of retaining that information.
Sahil, I just want to take it from here. Good evening,
Sure,
sir.
ma'am.
This
Sure,
is
ma'am.
Dr. Shivangi Sinha. And
Hi,
thank you so much for being the part of this, and you have accepted our invitation. Apologies, I was not there in your session because simultaneously I was having a guest lecture which was going on. But I really didn't wanted to miss this opportunity.
I was anyways giving Gyan too much on all the precedents, so I don't think if it was very pleasurable or not. It was
No,
not
sir, I
like a
think
regular general discussion.
I think, sir, all the gyans which are coming related to this topic is always pleasurable to hear. It's always music to ears. So thank you so much. And I think that these students might have learned a lot. And therefore, I was just constantly poking them that have a recording session. I'll definitely poke in anytime whenever I get time. And I'll thank sir personally that thank you so much, sir, that you accepted this invitation.
Thank
And
you so
apologies.
much, Ms. Sinha. Thank you so much.
Yes, sir. Sahil, you can take over.
For providing us with the judicial history, with the concept clarity, and also even analyzing the topic that how the law commission might view it in the future. It was really an insightful session for all of us. Thank you for us on being on board with us.
Thank you so much, Sahil. Thank you and I'm so sorry for delaying it. It was scheduled much earlier, but fortunately for me, there was too much work. But unfortunately, I couldn't do the session earlier.
It's fine,
So
sir.
thank you so much. It was a pleasure. Let's focus on more complex propositions and let my office do more research and help you guys out and help you save the ordeal of going through all the research and looking into judgments which run into 100 200 pages each.
Sure, sir. We are also looking ahead to for future collaborations with.
Thank you so much, Sahil. Thank you.
Thank you,
Thank
sir.
you.
Thank you. Thank you. Thank you. May I exit?